174.
Which means half is
137. It means that we can take a decision with 137.
We'll hear from the minority side as Evans Mensah's yet to be aired PM Express interview stirs controversy.
This is Top Story with Evans Mensah.
And Top Story is always brought to you by Vodafone and Prime Insurance. The NDC has lost a seat in Parliament, reducing their number to 136 MPs, leaving Parliament with a total of 274 members of Parliament. That is a controversial declaration by the Majority Leader and Minister for Parliamentary Affairs, Evans Mensah, who discloses in a yet-to-be-aired interview on PM Express later tonight at 9 p.m. that the NDC MP for Asin North, James Dachikwesi, has vacated his seat following an appeals court verdict. His argument is, on the back of this, what he believes to be a clear vacation of his seat, it leaves the minority to pass decisions with their number at 137, seeing that half of 274 is exactly that number, and what will be their case really before the Supreme Court to counter the suit that has been filed by leading members on the minority side in Parliament. We'll hear from the minority side as they admit some difficulties with James Dachikwesi's seat, but listen first to Evans Mensah, speaking exclusively to myself for a yet-to-be-aired interview on PM Express tonight at 9 p.m.
Evans, may I ask you, if you listen to the minority leader today, he said yes, they knew that they had 136. Right?
yes.
Assume true. Why is it that they are stressing? They are not stressing on 137 or 136. Because they know that technically the Asin North person has been ousted by the courts. They know.
But that seat hasn't been declared vacant.
It doesn't have to be.
No, but it has to be. The Constitution is clear.
Yes.
The process for declaring vacancy is there in the Constitution.
Listen. What's the process of declaring vacancy?
The Speaker has to formally inform the Electoral Commission.
Is that the case? That is not the case.
What's the case?
That's not the case. Look, I have the Constitution here. That is not the case. The Constitution provides in Article, what is it? 97, I should think. A member of Parliament shall vacate his seat in Parliament if any circumstances, if any circumstances arise such that if he were not a member of Parliament, would cause him to be disqualified or ineligible for election under Article 94 of this Constitution. There's that automaticity. You shall vacate your seat. Who says that it must necessarily come from the mouth of somebody?
So you're saying that...
So if the person decides not to make the pronouncement, that person will be there? No.
You're saying that once the court declares, automatically his seat is vacant?
In my understanding, a member of Parliament shall vacate his seat.
Yeah, but that clause isn't the same.
Shall vacate his seat.
Not disputing that, but that same provision spells out a series of circumstances.
No. Please read. What clause? That's what.
Spells out the series of circumstances.
97.1 says, a member of Parliament shall vacate his seat in Parliament, 1, upon a dissolution of Parliament.
Yes.
What do we need? Immediately the Parliament is dissolved, we vacate your seat.
True.
There's that automaticity.
It also includes when you absent yourself.
If he is elected as Speaker of Parliament, there's that automaticity. What processes are required? Thank you.
So your point is that James Dachikwesi, as it stands now, is not a member of Parliament?
That's my understanding of the law. That is why they themselves are saying that their number now is 136. And if it's 136, if it's out...
You use the word if.
And I know that he is. The number now climbs down from 275 to 274.
Which means half is...
137. So they are saying that they are admitting that we were 137. it means that we can take a decision with 137, assuming what they are saying is the right thing, that all of them had emptied the house.
But you say this about James Achikwesi's seat with authority. He's been in the House recently. He's been in the House, participating in the business.
I don't want to go into that.
No, but that is fundamental.
In the fullness of time, the law will take its course. I don't want to further go on that path. Let's leave that to the law to take its course.
But the law says there must be the people of Asin North need representation in the House.
Yes.
You're saying that as we speak now, the people of Asin North don't have a representation in the House. That's what the Constitution definitely intended.
Is that the case? You just mentioned to me that if a person absents himself for 15 sitting
yes, without permission.
Yes. The constituents wouldn't have, if such a matter arises, the constituents wouldn't have representation. We are not alluding to that.
Same applies in this case.
Same applies.
But so let's take what you're saying to be true on face value. Why hasn't Parliament then done the other thing, which is doing a formal communication for the Electoral Commission then to begin the process of making sure the people of Asin North are represented?
Let the law take its own course. I know in the fullness of time this will happen.
So that's how you ground your faith that you did the right thing on the day.
I'm saying that the fact that the minority themselves are saying that they recognize that their number is 136. Why are they saying that their number is 136?
They actually put it on the fact that on the day he had to attend to court.
Oh, they said their number
was 136 that day because the Achikwesi had to attend to court.
136. For me, the courts have made their pronouncements. And check the courts. There's no injunction, there's no stay of execution filed by...
They haven't filed the stay of execution, yes.
If judgment has been given, you haven't filed, you want to, further litigate, and there's no stay of execution. What does it mean?
The argument is that the president is a very astute, renowned lawyer. He should know that once the process has been filed, he should stay his hand. Even with an actual stay.
Is the president who is the electoral commissioner? In this case, is the president the electoral commissioner?
That as far as you're concerned, his seat is already vacated because the High Court has pronounced.
There are two issues here. Whether they had left the House, whether the processes of maybe injuncting a parliament sitting, duly constituted and doing business, if no issue is raised about a quorum, whether the parliament can go on and transact business.
Yeah.
That's another matter.
So why is this important? As far as the majority side is concerned, this is critical to the success or otherwise of the minority's case at the Supreme Court, asking the court to annul the decision to approve and pass the e-levy last Thursday, because it comes down to the numbers. The minority side had argued that because they left the chamber, the best numerical strength the majority side could marshal on the floor came down to 137, excluding Adjo Asafo, of course. And so that is not the numerical strength the Constitution has proposed, as upheld by the Supreme Court in declaring that you needed what they called a voting quorum, which comes down to 138 members of Parliament, because you're working with a total number of MPs being 275. If you take James Mensah's argument now that because of the court processes and the court verdict, latest in the appeals court case, that James Achikwesi in the Asin North seat is now vacant, then that leaves the minority side with 136 members of Parliament, brings the total number of MPs in the House to 274. Half of that is 137. That is what they had on the day. And that's what the majority that believes is indeed forms a voting quorum. That is why this is important. You remember that he kept referencing that the majority themselves admits that they have 136 members of parliament. Last week, the minority did a press conference shortly after the e-levy was approved. The minority leader addressed that press conference. He acknowledged that they had a difficulty that day with James Dachikwesin's seat, the Asin North seat, because they were not sure that they would be in contempt of court if he had actually come to the floor of Parliament to participate in parliamentary business that day. Listen to Harun Edrisu.
I should also let the Ghanaian public appreciate that this morning we walked in with some difficulty because of the matter of Asin North. He was essentially in court, and therefore, as a minority, at that material point in time, we were 136, pending whatever decision the Supreme Court and the other courts would have taken to guide our position. But we had advised his lawyers, who were also further going to file a stay of execution at the Cape Coast Court. We're still waiting for signals from the lawyers to know where we are, so that we're not in contempt of Parliament, or he was not in contempt of Parliament, following what the last decision was.
And so have they filed that stay of execution? And does that allow James Dachikwesin now back into the House to participate in parliamentary business? Let's clarify that shortly. I will bring in shortly the Director of NDC's Legal Affairs shortly. But let me bring in a parliamentary correspondent, Parker Wilson, who's joining us right now with a quick clarity. Parker, so we know that on Thursday he wasn't in the House. Harun Edrisu just explained that he had issues. They were not sure he would be in contempt of court, and they had a difficulty. Cheme Sabosu explains that it is settled now, that his seat is vacant. Have you seen James Dachikwesin in the House since Thursday?
Evans, let me put it on record that even on the day of the approval of the controversial e-levy, although the Senate Member of Parliament was not in the chamber, he was within the presence of Parliament. Now, days after, he has been seen in the chamber and within the presence of Parliament. In fact, today's vote and proceedings, which captures the minutes of the record for last Friday, if you check it, page 7, number 222, James Dache Asin North has been marked present in the chamber. And so for me, of course, I have seen him days after. It is only today that I haven't seen him in the chamber, but I must say that days after the approval of the e-levy, the Member of Parliament for Asin North constituency has always been in the chamber.
Parker, thank you very much. Let's clarify where we are with the legal issues that he has. That's one of the things that the majority leader references quite frequently in his interview with me, yet to be out of PM Express at 9 p.m. My correspondent, Joseph Akable, joins me right now. Joseph, so Cheme Sabosu says on the back of the court verdicts recently, his seat is vacant. What was the most recent verdict as far as this case is concerned?
And so that will be the Court of Appeal decision that the majority leader will be talking about. But in broad terms, there are 5 separate cases that are pending at the courts. We know one is a criminal matter where the MP is being prosecuted for forgery and perjury. Now, the 4 civil issues, 3 of them were filed by the MP himself at the Supreme Court, while one other was filed by Michael Ankoma Nimfa. He is the individual who initiated the action at the High Court challenging eligibility of the MP. And so the first application that has been filed by the MP at the Supreme Court was filed on March 24. He's asking the Supreme Court to set aside the March 22 Court of Appeal ruling, which Mr. Cheme Sabosu makes reference to. Now, it was that decision that struck out his appeal to the High Court decision of July 2021. And you recall that is the decision that stated that he cannot hold himself as MP. Now, that particular application that he has filed is to be heard at the Supreme Court on the 13th of April. The second application also filed by the MP is asking the Supreme Court to review its March 8 ruling that stated that a case that had been filed seeking to stop him from performing parliamentary duties had been brought to his attention. Now, there's a related application again by the MP asking the Supreme Court to hold on to hearing the injunction application until his review is dealt with. Now, it's interesting to note that this review ruling will be delivered tomorrow. And so depending on how that goes, the court may now deal with the injunction issue because automatically, if they rule on the review, it will mean that the application for stay of proceedings will be moot at that point in time. And so that may pave way for the court to hear arguments on whether the MP should be injuncted from performing parliamentary duties or not.
And Joseph, just for further clarity, so the appeals court verdict was to throw out his attempt to set aside the High Court decision that said he can't hold himself out as MP.
The appeals court decision, that one threw out his challenge of the July 2021. In fact, it was struck out. That's the appropriate word to use because the court took the view that he had not complied with certain processes that it had ordered that he complies with. And so we've heard his lawyers, they had indicated that they may consider an option of just having that appeal relisted. But the option that we know for a fact that they have taken so far is the application at the Supreme Court, asking the Supreme Court to set aside this Court of Appeal decision.
I see. Thank you very much, Blade, there with that intervention. So let's bring in the Director of Legal Affairs with the Opposition National Democratic Congress, TNDC. Abraham Amaliba joins us on the telephone line right now. Mr. Amaliba, so, I mean, Chairman Sabongs is right, is it not, that as we speak currently, on the strength of the Constitution, James Achikwesin's seat is vacant?
So let me start by saying good evening to your listeners. Osachi Mensah got it all wrong. Now, listen to me. The Court of Appeal in Cape Coast struck out a notice of appeal dated 28th July 2021. Our notice of appeal, was not filed on the 28th July 2021. Our notice of appeal was filed on the 2nd August 2021. So as I speak, our notice of appeal is still alive. It has never been struck out. 2, the court in Cape Coast, that the Court of Appeal in Cape Coast, went ahead and dismissed our stay of execution, not on its merits, but on the fact that because the stay of execution is predicated on the notice of appeal, then the stay of execution was dismissed, not on its merits. So if we step backwards, and I've already indicated to you that our notice of appeal is still subsistent because what was struck out was a non-existent notice of appeal. Our notice of appeal was filed on the 2nd August. So based on that, after the time of the passage of the e-levy, we had filed 2 processes. One was a certiorari application to quash the decision of the Cape Coast High Court. And 2, we have also filed, apparently because the stay of execution was not dismissed based on its merit, we have also filed or repeated the stay of execution. So as at the time that they were passing the e-levy, these 2 processes were filed in court. The effect is that it suspended the Cape Coast High Court decision.
So you have filed the stay of execution now?
As at the time of the passage of the e-levy, we had filed these 2
Clarify, was it on Thursday, the day of the e-levy passage, that you filed the stay?
Yes. On that day, yes.
Okay, but the filing a
so
stay...
So the effect of the 2, that's the stay of execution, and then the certiorari application, the effect of those 2 documents seeks to suspend the High Court ruling.
Okay, but the fact that you filed in itself, it's not guaranteed that in that stay is been granted, right? It doesn't suspend. It has always
been the case. In fact,
I mean,
it is that stay.
You lawyers disagree on that principle. That a mere filing of the case doesn't necessarily mean that the case is.
No, for stay, once you file it, all parties have to stay their hands off. You don't need to move it. Once you file the stay, that takes immediate effect. And that was what was holding him all this while until the Court of Appeal sought to dismiss the notice of appeal when they rather dismissed a non-existent notice of appeal filed on the 28th July, when ours was filed on the 2nd of August.
So you're saying that James Achukwuesin can go to Parliament and carry out parliamentary business and will not be in contempt of court?
That is so because the notice of appeal that was struck out by the Cape Coast Court of Appeal was not James Kwesi's notice of appeal. James Kwesi's notice of appeal was filed on the 2nd of August and not 28th July.
Thank you very much. That's the director of the NDC Legal Affairs there, Abraham Ali. But let's go to Parliament itself. Let's speak to the leadership of the minority, because you heard Chairman Sabongsu make countless references to the fact that even the minority side agreed their number is now 136. Muntaka Mubarak is the minority chief whip, and he knows all about that. He joins us on the telephone line right now. Mr. Mubarak, thank you for your time here on Top Story.
Good evening to you and your listeners.
Your friend and colleague says that even you agree that your number is 136 in Parliament because the Chicken seat is vacant.
Where is he conjecturing from? Oh, so he has agreed that his number is now also 136. Is that by implication what he's saying?
He says his number is 137.
Abu is in the US and he's not here. And then our colleague, Honorable Kum, is also sick. So they are also 136. Is that what he's implying? You see, this is the challenge that we have when people are dishonest in their presentation and then try to misrepresent the issues just to suit an argument. You see, when there are processes going on, as you, heard rightly from Honorable, Lawyer Amalba, who is leading our legal team in most of these things, they get the updates. In fact, for that day we were doing the levy, all the challenge we had was that they were in Cape Coast trying to file all these documents, the processes that he was saying. And I keep saying it is just an unfortunate situation that a government that is trying to take advantage of every little situation to do the wrong thing. They knew for the same day, the coincidence was there so much that on the same 29th, there's a hearing at the High Court for the criminal case. The same 29th, our colleague was supposed to appear in the Supreme Court. And as we may know, in the case of the criminal case, the lawyers keep telling us he has to be there in person. And that's all our colleagues opposite sought to do. That once he was out there in the High Court in person, they take advantage and rush through and get this e-levy passed. And you agree with me, weeks before, we kept arguing and pushing them, when are you taking this? And you remember that day, even the minorities had to draw their attention that we all told you that this surprised them. Now you are laying ambush. And that day, we had two options. And let me say, probably three options. We stay because Honorable Question was in the court. And because he's in the court, he hasn't returned. And because of the processes also in Cape Coast, he couldn't come into the chamber. So our number technically reduced to 136 for that day. And for during that period, we stay. They brought the chief transit minister in an ambulance, so they are 137. So we stay and then we vote and we lose. That was one option. The second option was for us to disrupt the sitting and then make it rowdy that, look, we didn't plan this. We didn't know about this sitting. Therefore, we are not ready for it. And then the Ghanaians and everybody around the world will say, you see the minority, they are trying to be violent, they are trying to be uncouth and all that. And then the third one was what we opted for. Fine. Since this is an ambush and they are using technicalities, let us also draw them into the technicalities. Let us move out and let's see. The same Supreme Court that said that the voting quorum or the decision quorum is 138. Let us go back there and let's see how they will rule. So we opted for the third option, which is to keep the fight against the e-levy alive. And for us, at that moment, that was the best strategy that was available to us because, one, we didn't want to be rowdy, we didn't want to be seen to be violently behaving in the chamber, and then two, We didn't want to give them legitimacy with our presence of 136. So the file and all the documentation at the Cape Coast Court has been filed now. Why is majority leader imagining that Honorable Atukwesi is no longer carrying himself as a member of parliament?
But has he been coming to do business?
Yes, he's been coming to parliament.
Yeah, but my colleague checks. He's been registered as present, but is he in the chamber doing business properly?
Yeah, I mean, you see, unfortunately, because it's a backbencher, sometimes I must admit, the way our chamber is structured, so that those who are sitting on the very last row, and especially if you are not lucky, a pillar is blocking you, you don't see much of them. And you see, this is a member of parliament, naturally, who is not a very, I don't know how to, for lack of a better word, very aggressive person. So he's a very calm member. And so most of our calm members, and because of the nose mask, sometimes the person is even around you, you will not see him. But we are here with him. We are here with him. So I don't know where the majority is conjecturing from. I mean, is there like what Atatia some few weeks ago was saying on your platform? We'll resist him, we'll get him to be sent out, and what and what. I mean, these are all rhetorics. The processes are not exhausted. Once the processes are exhausted, obviously, whichever way it goes, we will be law-abiding. But for now, the processes are on. The Supreme Court issues are on. The Appeals Court matters are on. The High Court matters are on. And they have not been exhausted. So, find out from the majority leader, how do we get seats vacant? Has it, been referred to privileges, and privileges come back with a report recommending, and the House voted, therefore the seat is declared vacant? Or is it that the court had declared his seat vacant and have notified Speaker, and Speaker have notified the Electoral Commission? I mean, these are the things. It is only at those stages that you can say that his seat is vacant. But for now, the processes are on, and Speaker has said it time without number. That look, so long as the processes are on and pending, the person still remains a member of Parliament. So I don't know where he's conjecturing from.
I mean, very quickly, James Abungsu quotes the question you asked. He quotes the Constitution to back his point. It says on Article 97, a member of Parliament shall vacate his seat in Parliament, if any circumstance arise such that if he were not a member of Parliament, would cause him to be disqualified or ineligible for election under Article 94 of this Constitution. 94 talks about dual citizens cannot stand as a member of Parliament.
Is it not what is being contested in court?
Well, the lawyer says...
Until it is exhausted, I can say it's like, I catch you in my backyard and I say that Evans is a thief, and then the police comes in, they say that, the matter is before the court, then I just say that Evans is a thief. You see, that's fair? I mean, the same Constitution, the 1992 Constitution, explicitly states, until proven beyond reasonable doubt in the court of competent jurisdiction, you cannot pronounce someone guilty. So the things that he's accusing about the breach of Article 94 are the issues in court, both at the Appeals Court, at the High Court is about the criminal one, so at the Supreme Court. So these are the reasons why these ones are at the Supreme Court and the Appeals Court, and they have not been exhausted. So on what basis is he claiming that the court had declared him not fit to be a member of Parliament? These are the issues that have been contested. So he should be patient. When the issues are exhausted, I'm sure the court will definitely get there and will act. But for now, he's a member of Parliament. He's been coming to Parliament. He's attending his committee meetings and carrying out all his functions. He's paid as a member of Parliament, and he's doing everything as a member of Parliament.
And that's Muntaka Mubarak. I'm grateful, sir. He's the minority chief whip there. More on this and a lot more happening in Parliament, including a ruling by the Speaker that being present in Parliament is not necessarily being on the floor in the chamber, but being within the precinct of Parliament. This is subject to some heated controversy on Newsnight after this.